Thank you. Good morning, everyone, and thanks for attending the program this morning. So I'm a partner at Lupster Nixon, and I'm a broad-based corporate commercial lawyer, but about 80% of my practice is in the franchising, licensing, and distribution space. So I happened to join the FOLA board because I volunteered. I'm the Toronto Law Association rep on FOLA. And after my first meeting, I came to the incredible realization that I have probably almost nothing to contribute to the FOLA board because the people on the FOLA board and the member organizations are lawyers, are real lawyers. They practice sort of real everyday law. And it's, your practice is sort of so far removed from my practice. But Alan mentioned that there was a need for bylaws and to help provide some guidance to county law associations to update their articles of bylaws. And I thought, maybe I could help in some way. So what follows and what you have is sort of my meager attempt to make a contribution to the association on behalf of the Toronto Lawyers Association. So you should receive, or you should have received, a memo that I prepared, and within that memo are sort of precedent bylaws that you could use to guide you to prepare your own bylaws, as well as some information about classes of membership, the purposes which you could use to describe the association's purposes, things like that. So could I have the first slide, please? Oh. Okay, so apparently Ian was kind enough to upload it on the website, so you should be able to find it there. So basically what happened is back in 2010, the Ontario government passed the Not-for-Profit Corporations Act, and but did not come around to preparing regulations until almost a decade later. And so the act came into force in October, I believe October 20th, 2021. And there was a 3-year transition period pursuant to which corporations, which were previously incorporated under the Corporations Act by letters patent and things like that, were allowed to transition their corporation to the new Ontario Not-for-Profit Corporations Act. So, but any corporation which did not transition was automatically deemed to have transitioned on the new act. And so as a result, in order to ensure that the old documentation that corporations had prepared, which comprised of letters patent, supplementary letters patent, bylaws, resolutions, comply with the new ONCA, let me rephrase. As a result of the continuation, certain provisions in the constating documents, which were the bylaws, resolutions, letters patent, and supplementary patents, were rendered invalid effective October 18th, 2024, and were deemed to have been amended so as to comply with the ONCA. There are, however, certain provisions in your old documents which were not deemed to be amended. That relates to the number of directors of the corporation. Next slide. If you have the 2 or more classes of members, the voting rights attached to those members, the right to delegate voting power under Section 130 of the OCA, and the distribution of the remaining property on the winding up or dissolution of the corporation. Next slide. So the OCA contains really comprehensive governing rules, and it's meant to approximate the kinds of rights and rules and regulations that are found in Business Corporations Act, which may be familiar to many of you in the room. But the ONCA contains different kinds of rules, and these governance rules fall into sort of 3 different categories. First, rules which are mandated by the ONCA. These rules, you can't change these rules. They apply regardless of whether you try, whether you've got anything in your constating documents that say differently. rules which can be varied from those set forth in the OCA, so it's permissive, so if you want to change the rules, you can, and supplementary rules, which is those things which the ONC doesn't cover. Next slide, please. So what you have to do in order to bring your law association's constating documents into compliance with the ONCA is, first of all, you have to file articles of amendment to remove, replace, amend any provisions which need to be changed in order to bring your new articles, or to bring your articles into compliance with the ONCA. Replace your bylaws with an updated version of the bylaws, and I provided you at Appendix A sort of a precedent set of bylaws that you can play around with. It may not suit your purposes, so you should always obviously get somebody who's familiar with bylaws to look and review and make sure it works for your association. And then what you should consider doing is file restated articles of incorporation. What that will do is that will take the original letters patent and supplementary letters patent and the amendments that you've made pursuant to the Articles Amendment and put them all in one nice, neat document. Next step. The first step in determining what you need to do is to determine whether your county law association is a quote, a non-public benefit corporation or a, quote, public benefit corporation. So the first question in determining that is it charitable? Now, we all know that county law associations are not registered charities, so it's not charitable. Although some of the work, no doubt, that you do is charitable. And second of all, the second sort of test is whether the association receives donations or gifts of more than $10,000 from persons who are not members, directors, or grants or similar financial assistance. Next slide, please. So if the association receives grants from the Law Society of Ontario or Learn or other grants that total more than $10,000, it is deemed to be a public benefit corporation. And if it's a public benefits corporation, that there are certain rules that apply under the ONCA. So first of all, not more than 1/3 of the directors of the association may be employees. For most county law associations, or I would say for all county law associations, that's probably not an issue. There are special audit requirements that you need to be alert to, and the articles must include a specific statement regarding the distribution of assets on its dissolution and winding up. So, next slide, please. So I've just highlighted for you in the memo some of the things that you might wish to consider amending when you file articles of amendment. So these are not exhaustive, and you have to look at the specific issues, and depending on how outdated your letters patent are, or supplementaries patent, and special resolutions and things like that, you have to sort of pay attention to what the real goals and objectives of your organization are and how you want to ensure that those are reflected in the work that you do. So under the old system, the goals of the association were called its objects or its objectives or whatever it is. So that terminology is now no longer used, and it's now called purposes. So you now have to sort of reframe. You can, in fact, use the same thing to serve. You can say it's to serve the needs of those lawyers practicing within the county, et cetera, to provide law library service, but you just have to reframe them as purposes rather than objectives. And I provided some examples of purposes, and that's set forth in Appendix B to the memo that you have. Next slide, please. So in sometimes historically in letters patent, sometimes members' rights and privileges were defined very broadly in the letters patent and supplementary letters patent. So now what you should do is you're going to define the members' rights, and you would just say, you have a certain number of classes of members, and then you just indicate in which class has the right to vote and which class has does not have the right to vote. And then you expand on other members' rights within the bylaws. And for an example of the various types of members' rights, I refer you to Appendix C. And I'm going to sort of a shout out to the Hamilton County Law Association because I actually used their precedent. It's on the website, so I wasn't sort of taking anything, I think, without permission, and I've attributed it. But they have a very expansive definition of members. And I think there's 8 or 10 or 12 categories of members, which is, probably more than quite a number of law associations. I think more than Toronto, in fact. So, next slide, please. The number of directors must be set out in the articles. And you can do this one of two ways. You can either have a fixed number of directors, or you can have what's called a floating board. So what you would do is you would say it would be a minimum of 3, which you need because you're a public benefits corporation, and a maximum of X. And so the X has to be a specific number, but that specific number will depend on the needs of your association. So for an association like, Carleton County Law Association, they might want to have a maximum board of 12 or 14. A much smaller law association like, and I don't want to pick on anyone, but say maybe Rainy River, might say, it doesn't make sense for us to have a maximum of 14 because we may only have 50 or 60 members. So they might wish to sort of put in a maximum of 6. So again, that maximum number depends on what makes sense for your particular county law association. Next slide, please. There's a special provision that will be inserted automatically when you file your Articles of Service Ontario. It relates to the fact that no part of the corporation's property is going to be allowed to be distributed to director or officer or of the corporation except in furtherance of the activities. And that's just standard language. Next slide, please. As well, assuming that each corporation is a public benefits corporation, each association is a public benefits corporation, you're going to put in a clause related to what happens to the property and assets of the association upon its dissolution, and this is just suggested standard language that you can include. Next slide, please. So some general comments about changes to the bylaws. It's no longer necessary to include a provision stating that directors shall serve without remuneration because the Act already provides this, and amendments to bylaws. So what this provision allows you to do, it allows directors to pass a bylaw and then act as though that passed bylaw is in effect as long as that bylaw is presented to members at the next meeting of members and as long as members approve it. If members approve it, then the bylaw takes effect retroactive to when it was passed by the members, to when it was passed by the directors. And if the members don't approve it, then what happens is the bylaw becomes null and void as of the date of the members' meeting. Next slide, please. So what follows, these slides sort of deals with things that you need to consider changing in your bylaws. So you want to sort of provide a definition of what your members are. Now your members and their voting rights will be in the articles, but you may want to be more expansive about what other rights members enjoy. And so again, for the categories of members and the rights and privileges attached to members, I refer you to Appendix C and D, and again with thanks to the Hamilton County Law Association. So next slide, please. The bylaws, so under the old OCA, directors could serve a term of up to 5 years before being required to stand for re-election. That's now been reduced to 4 years. So directors have to be re-elected every 4 years at the minimum. And they can still serve consecutive terms, which many of you do, to provide for continuity and things like that, and also provide progression up the sort of the executive functions. Under the old OCA, if there were elections for directors, often what would happen is that whoever got the highest number of votes would be then elected as directors. So this has now been changed. 3 minutes, okay, thank you. This has now been changed to provide that the director has to have at least a majority. So if no director gets a majority, or no group of directors get a majority, then you have to maybe eliminate the one with the lowest votes and then have a runoff and make sure that directors, that whoever's elected at least has a majority of votes, and you have to have continuous elections until that happens. Next slide. So under the ONCA, you can delegate powers to committees. However, there are limitations on the kind of powers that you can delegate to committees. And I've referenced, there's a note in the precedent bylaws that indicates what powers cannot be delegated to committees, and this is note 8 on dealing with section 14 of the bylaws. And so you can just have a look at that for your reference. Next slide, please. Again, membership classes, the articles should set at the name, and voting rights, and the other characteristics of membership should be set forth in the bylaws. Next slide, please. So bylaws also can provide for termination and discipline of members. There are protocols that are set out. These protocols are probably, in a sense, familiar to you. They probably align very much with the principles of natural justice. A member who's going to be disciplined should be made aware of what the allegations are against him or her or they. They should be given an opportunity to be heard and things like that, and that the person making the decision, the discipline decision, should be hearing the evidence directly and receiving the evidence directly. Again, these are probably issues which are quite familiar to you because they align with the principles of natural justice. Could you, next slide, and then again, the next slide. Okay, so this is the requirements for an audit committee for public benefit corporations. So if you recall in the earlier slide, I said that there was one of the issues if you're a public benefit corporation is that there were special requirements for the audit committee. So this chart here lists the type of financial statements that are required for your association depending on what your annual revenues are. So if your annual revenues are less than $100,000, an auditor requirement is, an auditor is not required unless members buy an extraordinary resolution, which is more than 80% of the members, as opposed to a special resolution, which is 2/3 of the members, pass a resolution saying we want an auditor. And same thing, that notice to reader, audit review engagement is, so an audit or review engagement is not required unless by special resolution, by extraordinary resolution. So if it's between 100 to 500, again, I've listed what the requirements are for audit and the type of financial statement. And if your association has more than $500,000 of revenues, then the auditor must be appointed and you must produce audited financial statements. Next slide, please. Majority of audit committee cannot be officers or employees of the association. And that's basically, I think I'm out of time, and that's basically the summary of the things that I might recommend that associations do. I guess the only disclaimer I have is the following does not constitute legal advice. That's probably a shocker to many of you, but it's for informational purposes only. I thank you for the privilege of presenting to you, and if you have any questions, you can call or email me, and I'll be happy to answer whatever questions I can. Thank you.